Supreme Court of the United States are admonished to
Assalamualaikum warahmatullahi wabarakatuh. Hello everyone, we are from Group 1. In this video, we will be presenting about what is law. My name is Danish Ara Parnyata.
Hi, I'm Alya.
Hello, I'm Assyifa Azzahra.
Hi, I'm Salsabila Zahara.
Enjoy the video.
So, what is law? In general, there is no distinct definitions of what law is because there are various types of beliefs, values, and customs that can shape the definitions of law. Also, different scholars can also have different opinions or different interpretations of the definitions of law. However, in general, there is definitions of law that is being used by many people, and that is rule of conduct that is developed by the government or society in certain territory. Next, we're going to be talking about one of the experts that studied the definition of law, which is a philosopher, John Austin. He stated that law is aggregate sets of rules set by a man as political superior or sovereign to men as political subjects. This means that law applies to everyone regardless of their statures. He also later stated that law conveys the rules made by the ruler who can give the punishments if the rule is being violated by a certain person. Next expert is Roscoe Pound, who sees the definitions of law from a sociological point of view. He stated that law is instruments of social engineering designed to maximize the fulfillment of the interests of the community and provide the smooth running of the community machines, which means that law embodies the controlling device used by both the upper class and also the lower class. So he believed there is two types of class, and law control both of the class. Next is John Solomon, who is a legal scholar, and he defines law from realist point of view. Realism itself means relating to the world and see the world as it actually operates. Because of that, he defines law as the body of principle recognized and applied by the state in the administrations of justice. Then there is the functions of law, which consists of administrations of justice, granting powers to certain institutions, maintaining standards, resolving conflicts, and lastly, as a social construct.
Now I'm going to explain about law and social order. Social order refers to the ways in which society remains stable enough to allow for coordinated productive and cultural activities, and also social order requires organization to enable coordinated and cooperative activity within social structures and institutions. And also social order means that there are social practices that ensure the maintenance and enforcement of appropriate ways of behaving. Social order is a core theoretical issue in the social sciences, and the problem arises because human beings are both individual and social. Social order is present when individuals agree to shared social contract that states that certain rules and laws must be obeyed and certain standards, values, and norms maintained. There are kinds of social order. The first one is customary order, meaning the provision of life arising from community engagement, and the violation of this norm causes reproach, insult, to the point exclusion from other members of the community. Second one is ethical order, or the rules contained in the human heart determine good and bad based on voice prompts his heart, and the violation of this norm is his own feeling, and the result is regret. And the third one is religious order, or based on belief in God Almighty and considered as profession from God, and the violation of this norm is opposing God's commandment, and the consequences for the violators are from God in the hereafter. And last but not least is legal order, and it's necessary because of the fact that the other three social rules is not enough to guarantee order in society or social life.
From the understanding of law above, we can already see the main purpose of law, namely, law as a guideline in people's life, regulating and controlling matter of many aspects in a country. If we learn about the deeper meaning of law, the real function of law is to create social justice, where every people has the same right and being treated equally in the rule of law, because it does not judge people based on their social status, wealth, or position. Whenever they are proven guilty by violating the law. They need to take the consequences. Law also plays a vital role in safeguarding its individuals and group right and interest in society. The legal term for this action is the maintenance of order and security by law. Law can also act as a tool for development, defined here as a way of community renewal in which the law is used as a mentoring instrument and an organizer of community's activity in a direction that is consistent with a conscious development and social reforms goals. Lawrence Fredman also stated that law also has a function as a conflict resolution, in which case it is viewed as a tool of managing conflict and a solution to an issue. The most important function of law is being used as a supervisor of the consequtor of the law itself, namely the government, in which the law also regulates what authority may and may not be executed by the peoples in governmental system. The institution that is responsible to create the law must remain focused on the common good of community as well rather than making law out of their own choices over their own gain. The community as one of the subjects which directly affected by the law must have a comprehensive understanding of the law in effects, as well as awareness and obedience to the law. The power holder or government must protect the community by not only minding their own interests, but also care about the welfare of the community as a whole. The law must be followed in accordance with a country's morality. However, the function of law that I have explained above may be meaningless because the law cannot work by itself, even it has no power to control. Many parties and organizations play a big role on the process of carrying out the function of law, so that there is no dysfunction of law, where the law loses their power and fail to govern the society. Both the community and the government must work together to realizing the function of law in harmony.
Okay, so now moving on, we're gonna talk about the classification of law. So basically, classification of law are different categories into which all areas of law can be collated. When we talk about the classification of law, we're gonna find 6 pairs of classification of law. As you can see, here are the 6 pairs. The first pair is public law and private law. As you can see here are the concern of each laws. In addition, public law consists of those fields or branches of law in which the state has interest as the sovereign, such as constitutional law, administrative law, and criminal law. On the other hand, private law consists of those fields or branches of law in which the state has no direct interest as the sovereign, such as contract law, tort law, and property law. The second pair is criminal law and civil law. Criminal law defined as the law of crimes. Since crime is an unlawful act, then all crimes or offenses are in essence created by parliament through statutes. And in civil law concerned with protection of rights. It also encourages enforcement of duties and taking care of provision of legal remedies. Next, we have substantive and procedural law. Substantive law creates rights and duties of parties. It also concerns with the rules themselves as opposed to the procedures on how to apply them. While in procedural law, it deals with the procedures on how to apply the law. It also consists of steps or guiding principles or rules of practice. So moving on to the fourth pair, here we have written law and unwritten law. As you can see here are the brief explanation of these two laws. In addition, written law usually represented in formal documents such as acts, while unwritten law mostly are not exemplified in the form of manuscript. Next, we have national law and international law. National law is the rule of law that only operates within the boundaries of a country. It regulates the relations between the state and the citizen as well as among the citizens. While in international law is the body of rules that regulates relations between countries and other international entities such as the United Nations. It is founded on international agreements or treaties. Last but not least, we have common law and equity. Both of them are restricted to countries whereby common law is applicable. Common law as a complete system of law is developed by circuit judges from English customary law. It applies the doctrine of precedent. While equity is developed by chancellor in dealing with petition about the rigidity of the common law. Equity complements the common law, but it could never replace the common law. Equity has a job to acknowledge the common law and tries to provide an alternative solution, such as the discretionary remedies. In conclusion, we have 6 pairs of classification of law, and all of these laws have different function and characteristic. So that was all about the classification of law.
That's all from us. Thank you and wassalamualaikum warahmatullahi wabarakatuh.